Okay. Craig's going to join us in a minute.
All right.
And I'm going to press start to get rolling.
There it is.
Good afternoon, everyone, and welcome. We're going to give everyone a minute before diving in. Okay, I see people trickling in. This is clearly a hot topic. We've got a full agenda, and we're excited to jump in. For those who are online, you can always engage with us and ask questions using your chat box. We're delighted you're joining us today to talk about the practical implications of perhaps new to some, maybe not to others, the DOL fiduciary rule. A quick few housekeeping matters before we get into the thick of the conversation. As always, we are recording today's conversation. We plan to share it with you following today's session. And you can, as I said off the top, you can use the chat box to engage the panelists here today and ask more practical questions given the DOL fiduciary rule. To get us started, I'm going to ask our wonderful panelists to introduce themselves, starting with Mr. Nelson.
Hi, and thanks, Parham. Thank you for having me today. My name is William Nelson. I'm an Associate General Counsel at the Investment Advisor Association. We're the leading trade group for fiduciary investment advisors, have about 600 members, 35 trillion assets under management, all the way up from the global big asset managers down to the 1 and 2 mom and pop shops. And prior to my time at the IA, I was a chief compliance officer for a $60 billion registered investment advisor in Denver. So I can definitely empathize with all the compliance officers on the call.
Thanks, Will. I guess this is where I got the Oregon mistake from. Mr. Wagner?
Well, thanks, Parham. I'm Ed Wegener, and I am the practice lead for governance, risk, and compliance with Oyster Consulting. We spent a lot of time working with our clients on issues such as the DOL's PTE, Reg BI, and those types of issues and challenges. So really appreciate the opportunity to join in today's discussion. Before I joined Oyster, I spent most of my career as a regulator. I was with FINRA for 22 years. Most recently, I was the Midwest Regional Director for the Midwest region.
Thank you very much, Ed. And over to you, Craig.
Yeah, thank you, Parham. And welcome, everyone. My name is Craig Watanabe. I'm the Director of Investment Advisor Compliance at DFPG Investments / Diversified Advisory Services. I've been in the business for 42 years. I've at a previous firm been a retirement advisor. So I've been on the other side of the fence as well as a chief compliance officer for 2 retirement-focused investment advisors. And I'm happy to be here. Thank you.
Thank you, Craig. Mr. Barnes.
Thanks, Parham. And hey, everybody. Randy Barnes, Director of our Product Development and Sales Engineering here at InvestorCOM, working with Parham. Prior to this, spent nearly 25 years in the industry, all in a product / customer-facing capacity with self-clearing broker-dealer systems as well as workflow management systems, all in the financial services space. So thanks for having me.
Thank you, Randy. And for those who are able to do some quick summation, I think we've got over 100 years of experience on today's call. I won't single anybody else, but anyone specifically out, but there are a few with a few more decades of experience than me. And speaking of me, I'm going to be your host and MC for today's conversation. And for those who haven't come across InvestorCOM, we're a leading regulatory software provider for wealth managers across North America. And our award-winning intuitive solutions are really well known in the marketplace for helping eliminate compliance risk and foster growth for our clients. Let's jump into today's agenda. So we're going to do a deep dive and start with an overview of the DOL retirement security rule, including the prohibited transaction exemptions 2020-02 and 8424. You've got the experts on the call/Zoom webinar here today, so please engage us throughout today's conversation. Then we're going to try to see how we can weave the specific requirements, that whether they intersect or they don't intersect. We'll dive into that piece in particular around how Reg BI and the retirement security rule are perhaps slightly interwoven. And then we'll talk about practical steps. How can a CCO, how can somebody in compliance, how can somebody who's working in the wealth management profession meet these new requirements and mitigate potential risks? All right, lots of moving parts, at least on my screen, and lots to cover today. Let's jump in on the retirement security rule, which has been a journey. If you were to actually draw a timeline going back perhaps a decade or more, there is a lot to share here. There's a lot of back and forths on perhaps other DOL rules that were proposed previously and maybe vacated through the court system. So there's plenty to talk about here. Maybe, Craig, I can start with you to provide an overview of maybe the history of the DOL fiduciary rule.
Yeah, thank you, Param. So it actually goes back to 2011 was the first time that the DOL proposed to redefine an advice fiduciary under ERISA. And I think it's important to distinguish the difference between like an investment advisor common law fiduciary versus an advice fiduciary under ERISA. The common law advice fiduciary for investment advisors is just that, it's common law. As a matter of fact, the word fiduciary does not appear in the Investment Advisors Act of 1940. So investment advisors are considered fiduciaries by precedent, going back to a 1965 case, SEC versus Capital Gains Research Bureau. And of course, we know that that's principles based. You know, you have the duty of care and the duty of loyalty. ERISA, on the other hand, which was enacted in 1974, has a statutory definition. So it was written by Congress, statutory definition for a fiduciary, and there are multiple different types of fiduciaries under ERISA. Now, what has happened is the DOL has, for the past 13 years, been trying to expand that definition and cast a wider net. Most recently, going back to 2020, the reinterpretation that we had to deal with, and PTE 2020-02. Prior to that was the 2016 regulation and the best interest contract exemption. And then here we are today with the retirement security rule.
Fantastic. That's plenty of time and plenty of proposals, and then work for the industry. And maybe as a way to kind of segue into the next piece is really the policy decisions and implications of this particular rule. And Will, can you provide a general overview of this new DOL fiduciary rule and what it's intended to do from a practical perspective?
Yeah, absolutely, Param. But, you know, before I forget, I'd be remiss not to mention happy birthday, ERISA. All right, 50 years old. Will there be a mid-regulation crisis? I have no idea. But all joking aside, I think Craig's exactly right. You know, this has been kind of, you know, whether you want to call it volleyball, ping pong, back and forth, proposals, court decisions. You know, I think really at a very high level, what the new rule does is just really increases the activities that will trigger a fiduciary status. And I know Craig touched on this. Basically, in establishing this new regulatory framework, I think the DOL really wanted to focus on protections that should be afforded to plan participants' rollover decisions. So again, they already have ERISA, obviously, for the plans. You have your own IRS prohibited transaction rules for the IRAs. But the DOL really wanted to focus on, you know, what are these rollover recommendations, rollover advice. So again, you know, even when you look at the preamble in the final rule, the DOL really expressed concerns over what they called marketing, sales pitches. You know, they really wanted to, you know, for those basically those financial advisors to match investor perceptions, you know, those trusted advisors, those wealth managers that, you know, providing impartial advice in my best interest. So, you know, going back to 1975, it's interesting to look at because at the time, there really wasn't, you know, really 401ks at that point. You know, they were just, you know, becoming available. It was all defined benefit plans. So it was really a different industry. So again, you can see why kind of this evolution from, you know, 50 years ago until now, it really has been a complete change in the regulatory landscape, but also in the investment landscape as well. So back in 74, the rule came into effect in 75. You have this 5-part test, you know, making a recommendation, you know, fee or other compensation, regular basis, mutual understanding. There's this really strict 5-part test where the DOL thought, you know what? I don't really think this captures a lot of what we're trying to capture with our fiduciary rule. So what the new rule does is say, hey, instead of this 5-part test, we're going to make it a 2-part test, but then have some subparts as well. So basically, you have to make a recommendation of any securities transaction or other investment transaction. So again, this is very broad, as Craig mentioned before. And the recommendation has to match a few different contexts. The first, again, you know, on a regular basis or as part of their business, they're making those types of recommendations based on a review of the investor's particular needs or their circumstances, reflects the application of professional judgment to their specific needs and circumstances, and may be relied upon. And that's really that, I think that's the part is really where you get into that, you know, meeting those investor perceptions. Also, if they acknowledge they're acting as a fiduciary under ERISA with respect to the transaction as well. So again, I think those are kind of the two different contexts, this trusted advisor concept. Hey, I'm holding myself out to you as the investor as a trusted advisor, or I'm holding myself out as an ERISA fiduciary, and I can't basically go back and take that away at a later time.
That was fantastic. You even remembered, Will, you know, Epsa's birthday. So good for you. You get a couple extra points for that. Thank you. Craig, let's shift the conversation to that couple of pieces that Will pointed out here, and it's that new definition of investment advice. How do you think this new definition, given your many years of experience, I'll keep calling that out, will impact the industry?
I think it's really important because if we go back to the last 2 iterations, I mentioned 2016 when we had the best interest contract exemption, and then the 2020 reinterpretation where we had PT 2020-02. This new definition is much more similar to the 2016 definition. And I think one thing that's really important is the scope is broader than the 2020 reinterpretation. So in the 2020 reinterpretation, it was really very much limited to rollovers. And rollover includes, by the way, a custodian to custodian IRA transfer. Under the IRS definition, that's considered a rollover. But in this case, for example, if an advisor were to recommend that someone open a contributory IRA and invest in a mutual fund, that will meet that first prong of the definition. And therefore, they will be a fiduciary. They will have a prohibited transaction because they will have made a recommendation that results in compensation to them, and they will need to rely upon an exemption from that prohibited transaction. So I think that's the first thing that's really important, is the fact that the scope is broader. And for those of us that were in the industry back in 2016, there wasn't this focus on rollovers. It was on retirement accounts, not rollovers, right? And I think we have to kind of go back to what the state of mind was then and react accordingly in terms of our policies and procedures, our workflows, and how we're going to comply with PT 2020-02.
Thank you, Craig. That's really helpful. And then, so, well, from a policy perspective, how does the new DOL rule fundamentally change the landscape? If you were to look at it from say, a wealth management firm going all the way down to an individual financial advisor?
Yeah, so Param, I think it's a really good question. I think it does, but at the same time, I think we already have seen a fundamental change over the last, 3, 5, even 7 years. So, we've always had the Advisors Act for investment advisors. Again, Craig mentioned it, through precedent, through Supreme Court cases, we've always been fiduciaries for the relationship. Then in 2019 comes regulation best interest. And I know Ed's going to talk about this, but again, raising the standard for broker-dealers, having to act in your client's best interest for those certain transactions. And again, on the insurance side as well, you have the NAIC, the insurance commissioners of the states, also have what they call this best interest standard for annuities and insurance products. And I think it's, at least 40 states or some now have adopted that. So I think we already have seen this fundamental change by really looking at, what's in the client's best interest. Again, you can look at ERISA, you can look at the Advisors Act, you can look at Reg Best Interest, NAIC, and what's really interesting is, when people reach out and say, "Oh, am I fiduciary?" I was like, "Well, which kind of fiduciary?" ERISA fiduciary, Advisors Act fiduciary. This whole concept of a best interest standard, which isn't really a fiduciary, but you're still acting in the client's best interest. So, I think the landscape already has changed in that respect, but I do think with this rule coming into effect, there will be, obviously a lot of changes. Because it did broaden it out so much, a lot more firms are going to be subject to these rules. You're going to have to put in policies, procedures, obviously make those investments. Training is going to be a huge part of it. Training your advisors. I know we're going to talk about this later. Are we going to try to rely on the education exception? How will we train our advisors to do that? Are we going to, go full-blown fiduciary? How are we going to train our advisors to, get this best interest disclosure form signed by the client? So I think there will be, a pretty large change, both with respect to policies and procedures, but also, those types of investments you're going to make, not only in the firm, but also in your staff.
Wow. So there's plenty of important changes on the horizon, and I think clearly there's a lot of questions that need to be answered by firms as well as financial professionals around, to your point, what type of a fiduciary is the particular individual, especially when you consider sort of at the bottom of this is this new notion of reliance on the investment advisor's experience and advice. So, Ed, again, with the focus of today's conversation being around practical implications, can you share how you see the requirements correlating between all these different bodies that Will just outlined?
I'll take myself off mute first. But no, Will did a great job of sort of talking about everything that's been happening in the context as we've been going down this road with respect to the DOL fiduciary requirements. And there is a lot of similarity and overlap, and it's important to really understand those both from the standpoint of the fact that you don't want to duplicate other requirements, but you also don't want things to fall through the cracks. So it's really important to understand where there's similarities, where there are differences, and that you're taking that into account as you're putting together your policies and procedures. So one of the things that I thought I would just kind of go through where I see some of the similarities, some of the differences, and then Craig and Will, please feel free to add any others that you see that are impactful. But what I think you'll find is that the nice thing is that these are all converging. So there's not a significant difference between the obligations, depending on which regulator you're looking at, depending on what role you're playing. But you also want to make sure that you're not missing any of these differences. So, starting with the impartial conduct standards of the rule, the obligations for care and loyalty, they changed from best interest language to care and loyalty under the amended rule. But that's very similar to the obligations that you have in the care obligation under Reg BI and the 40 Act fiduciary requirements, or as Craig said, the 40 Act requirements that include fiduciary requirements. So there's not a lot of difference there in terms of what the standard of care is between those. And then also there's the obligations related to reasonable compensation, best execution, things with respect to misleading statements. They all have analogous requirements, either with the SEC or FINRA or other regulators. So there's a lot of continuity there. With respect to disclosure requirements, the DOL is unique in terms of the fiduciary acknowledgement requirement. But for the obligation to disclose things like the nature of services and conflicts, they're very similar to the requirements that you have under Form CRS and Form ADV requirements. But I think the most interesting similarities are with respect to, as we've discussed before, the rollover recommendations, especially given the language that the SEC recently put out in its staff bulletin on account recommendations for BDs and IAs. They seem to really be looking to leave very little daylight between the obligations, or as little daylight as they can between the obligations. So if you look at the bulletin and compare that to the requirements under 2020-02, both are going to require that recommendations for rollovers be in the best interests of clients, and you have a reasonable basis for believing so. You don't put your interests ahead of those of the clients. The factors that you need to consider when making a rollover recommendation, whether it's under Reg BI, fiduciary obligation under investment advisors, or the PTE, are very similar. In both cases, they talk about needing to consider the option of keeping assets in the employer plan, and importantly, needing to obtain information about the employer plan, including cost information when making those comparisons. So when it comes to documentation and disclosure, there's some differences and maybe some not so different things in there. The DOL does require that you document and disclose the basis for the recommendations. So there is that specific requirement. The SEC does not require disclosure of the basis for the recommendations. And generally, as part of Reg BI, they said that you do not need to document the basis for recommendations in all circumstances. But if you read the language in that staff bulletin, they talk about how it's very difficult to demonstrate compliance and to ensure that you're complying with the requirements and monitor without having some type of documentation. So they kind of hedge there a little bit. So the disclosure requirements of the basis for the recommendations is different, but the documentation requirement might not be as different as you might think. So I think one of the questions that comes up is like, really, where are the differences? And I think, that's what you need to really understand as you assess, the programs that you want to put in place. Because I think one of the challenges that firms have with all of these different obligations is, how do you create a system and a process to make sure that you're meeting all of these requirements? And one of the things you want to avoid is any duplication, having two different processes for very similar things. So I think it's really important to make sure that you're assessing the similarities and the differences as you put your procedures and processes together. Importantly, too, because the amended DOL requirements don't go into effect, until September of this year for some, and September of next year for other requirements, it's important to also notice that some of the requirements of the new amended rules for the DOL are things that are currently required under Reg BI based on the language that the SEC has been using in the staff bulletin. So it's important that you make sure that while you're getting ready to comply with the DOL's requirements, that you make sure that you're already complying with the requirements of Reg BI and the other requirements that are in there.
Fantastic insights, Ed. Thank you as always. Folks, I'll take a quick pause here. I see phenomenal questions being asked, and I think this is a great opportunity for you to bring it on and challenge our over 100 years of industry experience panelists. Any questions that come up, again, we've got 15 minutes at the end of today's session to tackle these. There were a few points I want to come back to, Ed, that you touched on, which is disclosures and documentations versus, trying to weave the different policies together across the different institutions that are, or rulemaking bodies. Randy, you've got very much on the grounds experience working with our clients. You're hearing this through our working groups. How are you seeing our clients, as well as, I guess, industry participants, look at these requirements and try to implement them as a day one thing?
Well, it's really timely because we're actually meeting with our working group this coming Friday to dig into some of these very topics. For the most part, the consensus with our firms and our working group, they're largely covered based on their existing preparedness and level of policies and procedures to support the original 2020-02. So they're looking at this kind of working around the margins, right? some slight updates to the client disclosures, right? So whether it's, looking at it from the actual verbiage of the fiduciary acknowledgement, maybe some additional explanatory language that they can help to kind of bridge that gap between legalese and client friendly, things along those lines. Also looking at how we can help become more efficient at looking at the cost side of the assessment, and maybe drilling into some of those areas where finding costs can be challenging, and using this as an opportunity to not only be compliant, but be efficient, right? The other big one is, I think somebody actually may have brought it up in one of the chats here, is this whole concept of and Craig mentioned it too, the IRA to IRA transfer. How are firms going to look at that now? Is it hey, we're going to be consistent and just keep doing it because we're doing it today? Or is it this is an opportunity to maybe stop doing something that we were doing before because we don't want to continuously have our advisors filling out more forms and supervising more stuff, right? So that's I think going to be a big area of discussion. And then the last one is supervision, right? The broader the scope here, the more people have to look at now, making sure that their supervision is at a premium so that they can make sure the activity is in line with their policy and procedures, and how can we as a collective group, support each other in that journey.
Randy, you mentioned the IRA to IRA rollover and the decision point that the firms are going to have to make there. That's another area where, when you're considering that, is to take a look at what Reg BI might require, the fiduciary requirements might require in that. So if you're making a change because of the changes related to the final rule for the DOL, make sure that any changes that you do make are still compliant with Reg BI and other requirements.
Absolutely.
I hope folks are keeping track of all these phenomenal insights that are coming out through this conversation, because underpinning all of this is this concept of best interest, or whether you call that or accept the fact that it's somewhat underpinned by the fiduciary requirements. Again, moving assets from point A to point B, ultimately, does it have the investor's best interest at heart, right? And I think sometimes it gets hard to try to connect the dots, and what is the PTE, what line of in the sand does this fall into? If the underlying goal is to act in act in a client's best interest or the investor's best interest, it's somewhat simplified in a way. Let's do a deeper dive. Do you see, Mr. Nelson, do you see any additional guidance coming out from the DOL as part of this new set of requirements here?
Yeah, I do. I think that, they generally do try to be pretty helpful. I know they've actually already had a call once the rule came out for the public. People were able to ask questions. They tried to answer those. Obviously on the spot. You always hear the kind of the familiar refrain, facts and circumstances. So it's really hard to, drill down on those specific circumstances, but we did see with, when they rolled out the PT 2020-02, they did provide a list of frequently asked questions, FAQs. So I think they probably will do something like that similarly, or maybe even just update those for the new PTE. But I really do think we're going to see some guidance put out by the DOL once this rule comes into effect.
Fantastic. That'll be really helpful. I also see them appearing in a few working groups and effectively trying to educate and inform market participants on the premise of the policies. Why don't we talk a little bit about 2020-02, given the focus of rollovers, and maybe we can talk a little bit about what's changed and what hasn't. Craig, can I point this question your way? I know you have a lot of experience in this particular horizon. When it comes to 2020-02, have there been any very many material changes that you'd like to talk to?
Fortunately not. I think there were a few that gave me a little bit of pause in the proposal. Those, however, didn't make it into the final rule. So the main change was they basically took the template language for the fiduciary disclosure, which was maybe a few sentences. And now you have to add an explanation about the impartial conduct standards, which makes it about 2/3 of a page. So everyone is going to have to redo their 2020-02 disclosures to incorporate the new sample language provided by the DOL. But other than that, there really isn't a whole lot of change for PTE 2020-02, and I think that's a good thing.
Parham, to that point, one of the things Randy mentioned is most of the clients that he's been dealing with, have implemented 2020-02. We've seen something similar. So I think from that standpoint, following up on what Craig just said, it's a good thing, because I think to get prepared for the changes for 2020-02 for broker-dealers and investment advisors, it's not going to be, hopefully not going to be too heavy of a lift. Where I do see the biggest challenges is falling on insurers and independent producers based on the requirements of 8424. Insurers, because they have the supervisory obligation, though they're not fiduciaries, and then independent producers now becoming fiduciaries when they recommend insurance products to retirement investors. I think those are going to be really significant, both because of these requirements being new, but also because just the complexity of those relationships and how they're going to have to interplay. So I think that's going to be a major challenge and change.
Yeah, and I think 1.2, especially firms that are part of larger matrix organizations, will really want to look at their affiliates, because one of the things, and the DOL actually just did this in their qualified professional asset manager, their QPAM exemption. Basically, they're looking at criminal convictions, but now they've expanded it to foreign affiliate criminal convictions. Now, thankfully, in the final rule, they didn't have not the non-prosecution, deferred prosecution. But if you do have potentially a foreign affiliate who has a criminal conviction, you may yourself as a U.S. firm not be allowed to rely on the PTE 2020-02 anymore. So I think that could be a big deal. So again, if you're part of a larger, matrix affiliated organization, you really want to kind of look and say, hey, do we have those types of firms overseas, and could there potentially be that type of conduct?
Right, we're making our way. The retirement security rule, PTE 2020-02, we've dabbled a bit into 8424. One of the common questions we get from our clients is really around this sort of notion of education only. And I think part of what happened during the Reg BI journey was PTE 2020-02 popped its head out, and there was this sort of misconception / understanding in the industry that you can effectively not provide investment advice and really perhaps educate the investor. How do you see that particular notion changing as part of this new fiduciary definition and rule?
Yeah, I'm not quite sure if we're going to see that approach change. I think it should. I think firms really have to be thoughtful about doing that. The DOL does continue to draw a distinction between educational communications and fiduciary investment advice. And they discuss it in the preamble to the final rule. They point to Interpretive Bulletin 96-1 as being the source of guidance in determining what is considered education only and what's considered investment advice. So it's going to be really important that firms that are relying on educational advice exemption in any manner to make sure that they understand those distinctions. But one of the things that was important in the preamble is that the DOL did caution firms against steering clients to a particular course of action under the guise of education. And I would expect that they're going to be on the lookout for those types of things. Another interesting thing that they said is that they do plan to reevaluate 96-1 at some point in the future based on what they're seeing in terms of how firms are using this. So as a result, I think the important thing is that firms really understand the requirements and what causes a communication to cross the line from being education only to being considered fiduciary investment advice, to make sure that their policies and procedures are very clear in terms of those differences and when you cross the line. Importantly, making sure that individuals are trained on how to make sure if they're providing education only advice that they don't cross that line, And I would make sure that you're doing a terrific job of training your individuals on that so they don't inadvertently cross the line. But also importantly, I think some firms should really consider determining a means of monitoring. If they're going to go down the route of doing education only, that they have some means of monitoring communications in some way to look for red flags of the potential where people are crossing over the line. It's very difficult to do, but something that I think would be important. And important to all of that is make sure all of those efforts that you're undertaking, that you're documenting that. So if you're asked, demonstrate how you're doing education only and not providing fiduciary investment advice, that you can show the steps that you've gone to in order to be able to do that. Firms should be very thoughtful in doing that. Again, the DOL says that they're going to be on the lookout for that. So those are some steps that I think that you can take.
Thank you, Ed. And that's a key point of emphasis, at least that we hear in our discussions with our clients, as well as the DOL and others, is to be able to bifurcate between the number of rollovers that were executed on, let's just say over the past 12 months, how many of those were educational, how many of those were recommendations, how many were recommended and did not execute actually. And I think to be able to kind of take that from a data-centric approach will be very, very much paramount in this new era. Let me jump around a little bit. And I know, Craig, you've provided us with a draft set of, I'll call it a policy and procedures template as it relates to the new DOL fiduciary rule, which, by the way, for folks who are interested, following this webinar, you'll get a ping and we're able to disseminate that to you. Craig, as a seasoned professional in this particular space, any counsel for firms and financial advisory for professionals as they're looking to embrace these set of new requirements?
Yeah, I think it's really important. So unfortunately, the DOL rule, that definition that we went over on a prior slide, that is so complicated. There's so many different machinations that you can go through, so many different lines of analysis that sometimes it's difficult even for ERISA attorneys and experts to determine whether you trip that definition or not. And that's not what we want to do when we write firm policies and procedures. It's preferable that we write policies and procedures that are clear, they're straightforward, they're easy to interpret, and they leave very little gray area. And so that's what I attempted to do in the template policies and procedures. Now, out of necessity, to avoid a lot of this, well, what did you provide education, or did you actually provide a recommendation? To avoid those types of situations, the policy that I wrote says that if you are going to open a retirement account, any kind of retirement, if you're opening a retirement account, or if you're recommending, that funds be transferred to an existing retirement account, then the policies and procedures are applicable. And I think that's simple, for an advisor, for a compliance officer, a supervisor, oh, okay, yeah, you're opening a retirement account, or you may, you're transferring money in to an existing retirement account. Real simple in terms of, do the policies and procedures apply or not? And I think that what you'll find is that eliminates a whole lot of confusion and machinations with regard to, the complexities of the rule and whether it applies or not.
Hey, lots of work ahead, and we've got the September deadline. There is some confusion out there in terms of what's really got to get implemented by September 2024 versus September 2025. I've personally received that question for a number of folks. Anyone want to volunteer to tackle that piece? Our wonderful panelists here. And I think you volunteered, but you're on mute.
See, my plan was to volunteer and stay on mute, and that way nobody can hold me to it. No, I'll take a stab at it, and then you guys can feel free to correct me if you're understanding differently. But I believe that the September 2024 requirements are the fiduciary acknowledgement and the implementation of the impartial conduct standards. Everything beyond that would be things that need to be, they call it phased in, but need to be in place for September 2025.
Yeah, no, Ed, I think that's right. And it's actually similar how they did the PT as well. They had the impartial conduct standards, and then I think it was something like 6 months later, or even maybe I would say it was like February then July for the best interest disclosures. So I think it's similar to how they did it last time as well.
So I think there's a practical implication there. So Ed is absolutely right. But if you're going to have to comply with the impartial conduct standards, and you're going to have to provide this fiduciary disclosure starting September 23rd, 2024, I think you're probably going to want to have written policies and procedures. I don't think you want to have to try to comply with these things without written policies and procedures. So there was kind of a catch there. That's just my opinion, that at least from my perspective, if I'm going to require these elements, right, you comply with the impartial conduct standards and you provide the fiduciary disclosure, I want written policies and procedures. And rather than sort of piecemealing the policies and procedures, since they're policies and procedures very similar to what we're already used to, what we dealt with for several years after the 2020 reinterpretation, and even going back to 2016, the policies and procedures are fairly similar. My approach will be to implement the full-blown policies and procedures and comply with everything starting on September 24th. That's going to be my approach.
I would tend to agree. And the nice thing about that is then, for those things that aren't technically effective until 2025, it gives you an opportunity to fine tune that stuff and get ready for when those things are ultimately required. One of the things we've been doing are the retrospective reviews for firms that have implemented this. And it's been a good opportunity to find where there's issues. We've seen firms that are using forms that don't have all the information that is required. We have firms that have forms, but they're not being filled out correctly. They're not getting the plan information, those kind of things. So the opportunities to make sure all of that stuff is not only put into place in terms of procedures, but you get an opportunity to practice, assess, make any changes that you need before these things become effective.
This is fantastic, folks. We're seeing a lot of questions come in as well, and I think this is a great opportunity for us to take a couple more of these prepared questions and then jump into the thick of it with respect to our lightning round of questions. Let me do this. I just want to, this came up earlier in the discussion around education versus recommendations. The information you're seeing in front of you is largely from an exercise we did where we looked at a client of ours who's basically over the past 12 months had made over 14,000 rollovers. And of that, 7% of them only were educational exercises. So I think this question will come up again and again, and it's going to be a bit of a theme as we look at this particular industry data as we move forward.
And I think the DOL would want to know, of that 7%, how many were really educational versus recommendations.
Absolutely. I do think that's a key piece that's going to come up again and again, and it's to be able to provide that evidence over time around, hey, was that really a discussion or solicited by the investor versus solicited or hired me by the financial advisor. I think those are going to be common pain points going forward. Will, I want to come back to this because you mentioned it off the top around 8424, and I'm going to be a little bit short on time here, given the 15-minute guidance that we provided. With respect to 8424, can you summarize the key takeaways from a practical perspective for our audience?
Yeah, I mean, I think for 8424, the big thing is it's still available as long as you're not providing investment advice. I think what the DOL has done with their new fiduciary rule and also the PTEs, they really created this funnel, right? So they want everything to kind of funnel into the PTE 2020-02. So you still have the 8424, it's still usable by obviously the insurance industry, but if you're giving investment advice, they really want it to fall under that PT 2020-02. So I think that's kind of the big point and the big change from 8424 previously until now.
Got it. And this notion, I mean, I have it on the screen here, will insurance companies be able to effectively conduct retrospective reviews for their independent producers going forward? And does that kick in September of 2025?
I think the answer is yes to both of those things. And the retrospective review is specific to each independent producer and then that producer's sales of that insurer's product. So it's going to be, complicated that they're looking at a slice of the pie. Plus, they treat them almost like vendors, right? So they require that you do an initial assessment before you have an independent producer sell your product. And then when you do the retrospective review, you're supposed to assess whether you're going to keep them on as independent producers. And so, and then you have to report back findings from the retrospective review to the independent producer. So that's where some of that complication is going to come in those relationships.
That's a good point, Ed. Thank you. What about just maybe this is just for my own benefit, but Craig, when it comes to IRA rollovers, under the new set of requirements where it says, look, you don't really need to document and disclose IRA rollovers, but again, similar to what Reg BI says, it's probably good business practice. How would you implement that set of requirements at a firm?
Yeah, I think I would treat it kind of like a company-sponsored retirement plan rollover to an IRA. I would treat it very similarly. Same analysis, best interest rationale, cost comparison, the consideration of reasonable alternatives, and so forth.
Fantastic. Okay, I want to keep our promise to our lovely audience here. We have had fantastic interest. I'll skip past a couple of pieces. I'll make a quick announcement. Following today's webinar, the second it sort of closes, I have to find more technical ways of explaining that. You will be prompted to be able to download a couple of documents. One of them is going to be a summary, an AI-generated summary of today's conversation. As a technology company, we have that's our little dive into that notion, as well as an article by Mr. Watanabe, as well as a draft ERISA policies template that you can download and leverage from there. Having said that, let's jump into the Q&A session of today's conversation. Okay, let me pop this up. Let's get some of these easy ones out of the way. I see a question about RMDs. Who wants to take that one up? What about RMDs? Will distributions invested with the advisor be subject to scrutiny under the DOL requirements? I kind of know the answer to that. Anybody want to tackle that one?
Yeah, I'm happy to go. I think generally no, and the DOL did put language in the final release talking about, because there really has to be that recommendation. So if it's just, not discretionary, it's completely outside of the control of the advisor, it would likely not be a recommendation made by the advisor.
That's helpful. Thank you, Will. So for advisors who are already compliant with Reg BI, how should their policies and training change to reflect and be compliant with the new DOL fiduciary?
Maybe I could take that because I was talking about the similarities. One of the things that I did in preparing for today is I did sort of a matrix and a side-by-side of the requirements under Reg BI and the DOL requirement. And that's where you can really see the similarities, but also highlight the differences. That type of effort is probably worthwhile to go through and make sure that your policies and procedures that you have and your processes align across those different obligations. So where you have the duty and loyalty requirements under DOL, Reg BI, the fiduciary requirements under the Investment Advisories Act, that you have a process for that. And you don't have different processes across those because that can be really challenging for your people. But also being able to highlight where any differences are, making sure that you're including those differences in so things don't fall through the cracks.
I'm going to add to that one important difference between Reg BI and PTE 2020-02-8424 is the under Reg BI, the required disclosures such as Form CRS, those are general disclosures. They're not customer or transaction specific disclosures that are required. Now you do under Reg BI still have to do the transaction specific and rationale, like the best interest rationale. Why was this specific transaction in the best interest? What was the cost analysis with regard to this recommendation? and what are the alternatives to this recommendation. But those don't have to be delivered to the client. All you have to do under Reg BI is deliver Form CRS. That's a big difference. So if you're going to do what Ed is suggesting, that means that you're going to have to now go over and above Reg BI, and you're going to have to deliver PT 2020 type 02 disclosures, which include the recommendation-specific disclosures for each individual recommendation. And I don't know that a lot of broker-dealers are going to want to do that. Honestly,
I think that you can, yeah, to that point, I think that you can align the processes where it's appropriate to align them, to your point, and where there are differences to account for those differences specifically. So, where you're talking about the requirement to disclose under DOL, that, if you're doing something that falls under that, to make sure you're doing the disclosure. It doesn't necessarily mean to disclose the basis for your recommendation under Reg BI. So those distinctions are important to make sure that you have those in place, because you don't want to do things that you're not obligated to do, where it's not necessary.
Yeah, so Ed, I think the best example would be, let's say that we're dealing with a broker-dealer and we're subject to Reg BI, and we're only talking about a trust account that's non-qualified. So it has nothing to do with the retirement security rule or DOL, because it's a non-qualified account, right? But it is subject to Reg BI. So if we're going to harmonize our policies and procedures, Reg BI and PT 2020-02, to harmonize them, we have to defer to the least common denominator, which would be 2020-02. And that means you have to do all this other stuff that I don't think broker-dealers are going to want to do. And I think that simple example is really hard to kind of parse out. If you're going to harmonize your policies and procedures, right, what do you do about non-qualified accounts that are with a broker-dealer subject to Reg BI?
I do think that's where automation can help, where if you can distinguish between the obligations and the type of recommendation you're doing, it can be very complicated to do that on a manual basis. But if you have technology that can distinguish between the two, and then require the compliance based on the type of transaction that you're engaging in and the role that you're playing, that can be helpful. Again, difficult to do manually. Technology can help there if there's technology that can do that. It's just one of those things that'll have to evolve. But it's tough because of all these different competing yet similar requirements, right?
So Randy, does anyone have that kind of technology?
Sure about that, Craig. Let me get back to you on that.
I mean, the technology point is key, more so given that the retrospective review requirements haven't really gone away. If anything, they've actually ballooned given the 8424 overlay. And so, I mean, I kind of know some of the challenges you've probably had to help clients with respect to, hey, how do you, I don't know, take all of those rollover activity, both recommendations as well as executed rollovers over the past 12 months or so, and you have to do this on an annual basis. How can you confidently say that those have been reviewed? And Craig, I know you've done plenty of writing on this, whether it's been you take a sampled approach or you look at every single rollover. That exercise in and of itself, in my opinion, at least, it balloons into a huge make-work exercise, especially if a technology-centric solution has not been adopted. But again, I'm biased. I'll put that.
Well, just one thing on that point too, and you're talking about the retrospective review, which is an annual point in time. But remember, you've got the self-correction requirements, and then there's this requirement if you fail to make a disclosure and you got 30 days to fix it and stuff. So if you're waiting until once a year to do that, you might already be missing the boat. So it's almost even more regularly that you should be monitoring this stuff. And again, that's where, it can be challenging. It can be done manually. It's more challenging that way.
All right, folks, we've got a lot more questions than we have time. I think I'm going to try to keep hammering these through just so we are keeping our word to our audience. There's this question around client solicited rollovers. So if a client comes up to an advisor and said, hey, I want to move my assets from point A to point B, does that need to be documented, potentially disclosed to the end investor?
Yeah,
Go.
Oh, no, go ahead, Ed.
Well, I was just saying, from my point of view, if the firm isn't making a call to action, it's not a recommendation and wouldn't fall under. That being said, I would document the fact that that was the case, and probably have the client attest to that, just so that you have some documentation to demonstrate that it wasn't a recommendation by the firm.
Yeah, and that's actually, Parm, that's a question we get from a lot of our members as well. Kind of how do we tell if it's solicited, unsolicited? And we do provide, you know, that type of documentation. I think and the DOL was pretty explicit. They said, hey, that documentation, you know, doesn't necessarily mean it is unsolicited, but we can use it to, you know, show that intent. I think one of the interesting question that comes up is, hey, you know, they may decide to roll over, but what if you're providing specific investment recommendations of how to invest those assets? That's really where you get into, you know, a lot of difficult issues, because then you do have a recommendation of how, you know, plan assets are going to be invested outside of the plan. So again, you really want to kind of take those case by case, but yeah, it can be a really gray area looking at these unsolicited versus solicited. But I think Ed's exactly right. If you're going to do it, get that documentation.
I'll defer back to my policies and procedures. You know, in that case, it doesn't matter because they're opening a retirement account and it would have been subject to my policies and procedures. Let's make it simple.
I've read your policy, Greg. I think when it comes to that idea, it's the last thing you want is your firm and your financial professionals trying to decipher exactly which way to go. I think if you're a qualified accountant, you fall under that policy and procedures document, like you're saying, and I think that's sound advice. Craig, you've got a direct question to you and addressed to your last name, which is fantastic. In addition to if you are opening or funding a retirement account, don't we also have to worry about when the source of funds are a retirement account funding a non-retirement account?
Yeah, that's a really good question. Now, I want to go back for just a second. When dealing with ERISA, it's generally a two-step process. One, determine whether you're a fiduciary, and that's when the retirement security rule comes into play. Did you make a recommendation? And if so, you're most likely going to be an advice fiduciary under ERISA. The second thing that's really important, and this is going to answer some of the other questions that came into the Q&A as well, is, okay, you're a fiduciary. Did you have a prohibited transaction? And a prohibited transaction is created when the recommendation created additional compensation to the advisor. So let's say that you have a client who's taking a retirement distribution from their 401k, they're retiring, and they're going to not roll it all over, but they're going to take, you know, a taxable distribution. If you didn't, well, let me use a different example. So let's say that you have a client's retirement account and you have their trust account, and they're taking a distribution from their retirement account into their taxable account. If you didn't earn any additional compensation, you don't have a prohibited transaction. There was also a question as to whether if you're a fee-based advisor, right? In other words, you don't receive any transaction-based compensation. You're just earning a fee for the consultation. Likely there, your recommendation didn't increase your compensation, so you don't have a prohibited transaction. So I think if you think along those lines with ERISA, number one, am I a fiduciary? Did I meet the definition of the retirement security rule? Number two, do I have a prohibited transaction? That can answer a lot of these questions. So going back to the original, there are some scenarios, and so that was a really insightful post. There are some scenarios where, yeah, that would slip through my policy and procedures.
There you have it, folks. We've been able to crack Craig Watanabe's code here. This has been fantastic. I know it's 1:59. I see some questions that have not been answered, so I'll reach out to the panelists as well and try to reach out to you directly with some responses here. 1:59 on the dot. Thank you all for your time, and then don't forget, respond to the survey questions that are going to pop up on your screen in a minute. Thank you all.
Take care.